Hello and welcome. My name is Maria Mancini, and today we're going to talk about ethics. We will address the ABA Model Rules of Professional Conduct, Ethics Rules on Attorney Communications. Specifically, we're going to discuss Rule 7.1 on communications concerning a lawyer's services, and then Rule 7.2 on communication concerning a lawyer's services, these specific rules. We will also discuss how to apply these rules so you can make sure to stay out of trouble when holding yourself out to members of the public, whether it be in advertising, marketing, or promotions. As I said, my name is Maria Mancini. I'm a licensed California lawyer. I've been in practice for about 25 years. I practice both litigation and transactional work, and I split my time between LA and Italy. My contact info will be on the screen for you. If you have any questions or comments, please feel free to reach out to me. So let's get started. The way we'll conduct this seminar today is as follows. First, I will lay out the rule for you, and then we will have a discussion on its application. An outline will follow on the screen so that you will be able to keep up. Let's take a look at the first slide. Here you have my information, my background information. So part one, we're going to discuss Rule 7.1 and then its application, all right? Rule 7.1, communication concerning a lawyer's services. I want to point out before we go any further that today we're discussing the American Bar Association's model rules. You should also consult your state and local bar rules of the jurisdiction where you practice. These rules that we're talking about today are a guideline for those state rules, and you will be held to the standards in the jurisdiction where you practice. So, moving right along, Rule 7.1 states as follows. A lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. A communication is false or misleading if it contains a material misrepresentation of fact or law or omits a fact necessary to make the statement considered as a whole not materially misleading. That's the whole of it. Rule 7.1 is actually pretty short, but its implications and applications run far and wide. The application of this rule, we will cover the following. 1, misleading truthful statements. 2, communication regarding lawyer's background. 3, conduct. 4, communication regarding firm presentation. 5, multi-jurisdiction lawyers. 6, communication regarding practice areas. And 7, communication regarding name. So now we're going to discuss the application of Rule 7.1, and after we've done this, we will address the specific rules as outlined in 7.2. So Rule 7.1 talks about any communication regarding a lawyer's services. That includes advertising. The communication must be truthful. It cannot be misleading, truthful statements. What is misleading? Misleading, truthful statements are statements that are those half-truths that leave out crucial information. For example, if the lawyer says he is the cheapest lawyer in the neighborhood, but he doesn't tell you what he means by neighborhood. Are we talking about the block he lives on? Are we talking about the street where his office is located? Are we talking about the city, the county, the state? We don't really know. So this can be a little bit misleading. This is what is referred to as a misleading truthful statement. And these are prohibited. What this lawyer would need to do was to be more specific about how he's the cheapest lawyer in the neighborhood. Maybe he's just exaggerating a little bit, but in any case, he's violating the rules. Now, if there is a misleading, truthful statement, it is going to be evaluated on whether or not there is a substantial likelihood that a reasonable person would believe something about the lawyer where there is no factual basis for that belief. For example, if the lawyer says he's a lion in the courtroom, but actually he's never appeared in court, or he doesn't appear that much in court, a reasonable person would be led to believe that he's in court all the time and that he's a lion, he's ferocious, that he's a winner, that he's aggressive, and all those things that go along with descriptions that you would attribute to a lion. If the lawyer actually has very little experience in the courtroom and he's saying that he's a lion in the courtroom, a reasonable person would believe this statement. This is why it's considered a misleading, truthful statement. Another example of a misleading, truthful statement is if it's presented in a way that a reasonable person would think that he needs to take action because of something the lawyer told him, but he really does not need to act that quickly or to act at all. An example of this situation would be if the lawyer tells the prospective client, you better take action in 24 hours or you're going to lose your house, or your house is going to be foreclosed on, or a million other things to scare the client or prospective client into thinking that he needs to hire a lawyer right away, when that may not be the case at all. This is considered a misleading statement. Now, obviously, if it is true, then it's not misleading. But in this example, it's not true. So it would be considered a misleading, truthful statement. Another example of a misleading statement are statements about a lawyer's achievements. If a reasonable person would have certain expectations that his case would turn out a certain way because of something the lawyer had told him, but the lawyer had left out some important details. What comes to mind in this kind of scenario is a situation where the lawyer might say, if you spilled hot coffee on you at a restaurant, I could get you $3 million, just like I did for my other client. But then the lawyer doesn't tell you, or he failed to mention, that the other client had serious third-degree burns, major skin grafting done to repair the damage, that the injury was to the pelvic area. In other words, the lawyer is leaving out crucial information that may show the difference between that $3 million case and your case. This would be considered a misleading statement. Now, another misleading statement would be a statement about a lawyer's fees compared to other lawyers. This does happen often, not always, but often. A lawyer might say, hey, we are the cheapest trust and will lawyers in the state. But he fails to tell you that they're really cheap because all he does is give you maybe a template and you have to fill in the blanks, and it's more of a do-it-yourself kind of outfit rather than the kind of service that would be provided by another lawyer that probably charges a little bit more. That's considered misleading as well if he's not telling you the difference between why his fees are so much cheaper than the next guy's. Another area where misleading truthful statements comes up is in firm names. But before we get to that, I do want to point out that there is a solution to this problem that works in most cases, and that's a disclaimer. If you have an ad or a marketing statement, and you're saying things that are not necessarily clear, but you want to stay out of trouble, you can put down a statement of a disclaimer that says something like, information contained in this website is intended as general introductory information only. The information contained on this website is not legal advice. It should not be construed as legal advice and should not be relied upon as such. Something along those lines, telling this prospective client that, hey, maybe not everything in here that we're telling you is actually going to happen in your particular case. These disclaimers usually do make sure that they are the correct font size and type, and they're conspicuous, and follow all the other rules that we talk about in a different section of the model rules. Now, getting on to firm names. The way firm is presented and the name of the firm can also sometimes be misleading to a client. And we have to watch out for these instances because they can violate Rule 7.1. Misleading firm names. Here we're talking about firm names, letterhead, professional designations. These are all considered lawyer communications, and they're considered communication of the lawyer's services. For example, firm names that are okay, if not misleading or false, are as follows. These are okay, perfectly fine under the rules. 1, the firm name lists all the current members of the firm. Smith, Johnson, and Groves, for example. There's only 3 guys in this firm, Smith, Johnson, and Groves, and their names on the letterhead in that way. It could also list just some of the current members. For example, Smith and Groves. Let's say Smith and Groves are members of the firm. They're not the only members. Johnson's in there too, but Johnson's name is not on the letterhead. That's not misleading at all. Names of deceased members. For example, Smith, Johnson, and Groves, and now Johnson is dead. That's perfectly fine. If Johnson was an actual member of the law firm and now he's deceased, they can use his name in the firm name. Or they can also go by a trade name. They can also use a distinctive website address like Smith Law for You. Smith, LAW, for the numeral 4, and you. That's perfectly fine too. This is not misleading. You can also use a social media username, Smitty Smith. That's acceptable too under the rules. Now, misleading or false firm names implies a connection with a member of the public that's not necessarily part of the firm. These are considered misleading and untruthful, and in some cases, even deceitful. A misleading or false firm name implies when there's a connection with a government agency, but there really isn't one. When there's a connection with a deceased lawyer, but he was not actually part of the firm. Or when the name states a lawyer who's not even associated with the firm. Also, with someone who is not a lawyer, but appears to be one because his name is on the firm letterhead. For example, Smith, Johnson, and Groves. Johnson is just a paralegal. Johnson is not a lawyer, but a reasonable person would think Smith is a lawyer, Johnson's a lawyer, Groves is a lawyer. That would be misleading to the public. Any firm names that are also considered part of public or charitable legal services organizations is also considered misleading. For example, the firm name might be Smith Legal Fund Foundation. I don't know what the Smith Legal Fund Foundation is, but it sounds really official. And it sounds like it might be like a quasi-public entity or maybe some kind of charitable legal services organization. If it's not, then it's considered misleading and violative of these rules. Lawyers holding themselves out as practicing together in one firm when they aren't is another area of misleading firm names. That would be a situation where Smith, Johnson, and Groves are not really working together. They haven't filed as one firm under the rules. They have maybe like a loose affiliation. Maybe they just share office space. They would not be able to hold themselves out as being together in one firm by using the name Smith, Johnson, and Groves. Again, please check the rules of your local jurisdiction because they may have even more stringent rules. The law firm name using the name of someone holding public office comes up every once in a while. If the firm name has the name of someone who holds public office and that person is not actively or regularly practicing with the firm because they're holding public office, then that would be misleading to the public because it could lead a member of the public to believe, oh, this guy's a part-time senator and part-time lawyer. And when he's a lawyer, he's at this firm. To us as lawyers, that wouldn't make any sense, right? But to members of the public, they don't know. That might be something permissible or possible. It's not, and it's misleading to the public, and we should not be engaging in those kinds of things. Now, moving right along, we've completed the short discussion on Rule 7.1, which gives you the basic outline. Again, I want to stress, we're talking about the model rules of professional conduct under the American Bar Association. You need to also consult with your local state bars to make sure that you're abiding by their rules. In most cases, their rules will overlap with these rules, but you need to make sure that that's the case. So, pardon me, we skip down to Rule 7.2. Rule 7.2, communications concerning a lawyer's services, specific rules. 7.2 builds on 7.1, like a lot of the rules under the ABA rules of professional conduct. 7.1 gives you an outline, and 7.2 gets you into some more detail, okay? Rule 7.2 reads as follows. A lawyer may communicate information regarding the lawyer's services through any media. A lawyer shall not compensate, give, or promise anything of value to a person for recommending the lawyer's services, except, so the lawyer can, in these cases, except that a lawyer may, 1, pay the reasonable costs of advertisements or communications permitted by this rule. 2, pay the usual charges of a legal service plan or a not-for-profit or qualified lawyer referral service. 3, pay for a law practice in accordance with Rule 1.17, which we're not going to be discussing here today. 4, refer clients to another lawyer or a non-lawyer professional pursuant to an agreement not otherwise prohibited under these rules that provides for the other person to refer clients or customers to the lawyer if one, the reciprocal referral agreement is not exclusive, and the client is informed of the existence and nature of the agreement. And 5, give nominal gifts as an expression of appreciation that are neither intended nor reasonably expected to be a form of compensation for recommending a lawyer's services. C, a lawyer shall not state or imply that a lawyer is certified as a specialist in a particular field of law unless the lawyer has been certified as a specialist by an organization that has been approved by an appropriate authority of the state or District of Columbia or a U.S. territory, or that has been accredited by the ABA, and 2, the name of the certifying organization is clearly identified in the communication. D, any communication made under this rule must include the name and contact information of at least one lawyer or law firm responsible for its contents. And that's the gist, that's the whole, of Rule 7.2. We'll now discuss its application. In discussing its application, we're going to cover A, information, B, compensation, C, referrals, D, gifts, E, certified specialists, and F, contact information. Why are we discussing these things under application? Why? Because a law firm is a business, and being a lawyer is a profession. It's not really a hobby, it's actually a profession. We need clients, and we need to find creative ways to get those clients. And sometimes some colleagues get too creative in their actions, getting new clients or new business. And those actions can border on not just annoying members of the public or harassing members of the public, but also a violation of the law. These rules are designed to prevent that from happening. This rule, Rule 7.2, allows public dissemination of information concerning a lawyer's name, a law firm's name, the lawyer or firm's address, email address, website, telephone number, the kinds of services the lawyer provides, information about fees, whether the lawyer speaks a foreign language or not. These are all things that a lawyer is allowed to tell the public about when he's providing information in effort to get new clients. The lawyer can also say if he has any references, and he can state who they are as long as he gets permission from these persons. He can also state the names of clients regularly represented by him or the firm, and any other information that will market his services, as long as it falls within these guidelines. Rules regarding communication on recommending a lawyer. Now, there are certain things that a lawyer should not and cannot do. Cannot pay others for recommendations unless it's provided for under these rules. A recommendation is someone who endorses a lawyer's credentials or abilities, competence, character, or any other professional qualities. That's a recommendation, and that is the way recommendation is defined under these rules. Recommendation isn't, hey, You should call so-and-so, he's a great guy. I don't think that that qualifies as a recommendation. Again, not saying anything about the lawyer's credentials, abilities, competence, character, great guy. I don't know if that goes to character. Sometimes yes, sometimes no. And it's not talking about the professional qualities of the lawyer either. So it's really not a recommendation. Probably doesn't get in trouble under these rules. When we talk about directory listings and group advertisements, we're talking about a different area. This is where there's a list of lawyers by practice area. You've seen these in magazines and journals or online websites. Those are not considered recommendations. They're just listings, and they're listings by practice area. Now, if there is an area or a portion of that listing that does make a recommendation, obviously that would have to come under these rules. But just a directory listing for or a group advertisement under your practice area is not going to be considered a recommendation, and those are everywhere, far and wide. Now, a lawyer can pay for advertising and communications. You're probably wondering, we see lawyer ads and communications everywhere. So how is it getting done? It seems like it's complicated, or it seems like they might be violating the law. Well, no. A lawyer can pay for advertising communications. How else is a lawyer supposed to get business? How else is supposed to stay in business? So some examples of permissible areas where you can pay for advertising and communications is directory listings, which we discussed, online directory listings, newspaper ads, TV ads, radio airtime, maybe some kind of domain name registration, sponsorship fees, any kind of internet-based advertisements, as long as it comes under the rules, or group advertising. A lawyer can pay people who provide marketing services to him as well. For example, it's perfectly permissible for a lawyer to pay a publicist, public relations agent, business development employees, TV and radio station employees, or even spokespersons, and of course, website designers. It happens every single day, and it's perfectly permissible. A lawyer can also give gifts to a person who's recommending or referring the lawyer if it is a nominal gift. So you would think, oh, well, I can't even give a gift to someone who's recommending me to someone else or referring me some business. You can give a gift. It just has to be a nominal gift. What a nominal gift is, it's something that's not more than a token item, something that you might give at a holiday or birthday, or some kind of ordinary social hospitality gift. A gift is prohibited if it's offered or given in consideration of any promise, agreement, or understanding that such a gift would be forthcoming, or that referrals would be made or encouraged in the future. On the surface, it seems like a fine line, but if you think about it, it really isn't. A nominal gift is something that you would normally give during holiday time to just about any close friend, right? So you're going to be okay with that. Gifts that are prohibited are when you're giving the gift in hopes that they're going to refer business to you, and you're being forthcoming about that or obvious about that. That kind of gift is not considered a nominal gift. Now, a lawyer can also pay for generating leads if the generator does not recommend the lawyer. This could be a tricky area. For example, internet-based client leads. Everyone, the lawyers, the law firm, have to abide by the rules in these model rules of professional conduct. And as I keep stating over and over again, the local rules of your state bar where you practice. The internet-based client leads can be paid, but the lawyer has to abide by Rule 1.5 in the model rules, which talks about the division of fees. Rule 5.4 in these model rules, which discusses professional independence of the lawyer, fiduciary duties, and Rule 7.1, which we just covered, communications concerning a lawyer's services. We're not going to discuss Rules 1.5 and Rule 5.4 here today, but we did just cover Rule 7.1, communications concerning a lawyer's services. Now, to comply with Rule 7.1, a lawyer cannot pay a lead generator that states, implies, or creates a reasonable impression that it is recommending the lawyer or is making the referral without payment from the lawyer or has analyzed a person's legal problems to determine which lawyer he's going to refer to. That's not permissible under Rule 7.1. Now, it seems like there's a lot of things that aren't permissible under these rules, but there are quite a few that are permissible. We don't want to keep you from making or finding new clients and making money, right? Another area where a lawyer can pay for services is the usual charges of a legal service plan or a not-for-profit or qualified lawyer referral service. We hear about these all the time. They call us up and ask for our business on occasion. So they are out there and they do make themselves be heard. A legal service plan is a prepaid or group legal service plan that helps people find a lawyer. It assists people in finding lawyers. A lawyer referral service is an organization that holds itself out to the public as a lawyer referral service. So these things are a little bit different. The lawyer referral service is consumer-oriented. It's a consumer-oriented organization that provides unbiased referrals to lawyers with appropriate experience and lawyers that can give clients certain protections, such as a complaint procedure if the client's unhappy, or malpractice insurance coverage. A lawyer referral service is also one that is approved by an appropriate regulatory authority as affording adequate protection for the public. This is different from a legal service plan, which, as I mentioned before, is either prepaid or a group legal services plan that helps people find a lawyer. Now, I'd like to speak for a few minutes about referring to other lawyers or non-lawyer professionals, because this occurs a lot in our profession. It is permitted if it's reciprocal, but not exclusive, and the client is informed. So you have two lawyers, they refer cases to each other back and forth. They don't have to refer those cases back and forth, or those clients back and forth. It's not an exclusive relationship where one lawyer has to refer to another lawyer in particular, and where in every instance, the client is informed of the referral or even the referral arrangement. Payment is not permitted under these rules if the lawyer is making only a referral. In other words, he's solely a source of referral and that's it. There's no payment that's permitted under that scenario. Again, check your state and local rules about referring attorneys, because this may vary from state to state. We are going to move on here to communications about fields of practice. When a lawyer is holding himself out to the public, either in an ad or a marketing campaign or online, and he starts to discuss his fields of practice, there are certain things that he can say. He can say if he does and does not practice in a particular area of law. He can say he concentrates in, he's a specialist in, he practices a specialty of, or he specializes in. These are all permissible phrases to use when you're talking about the area of law that you practice in. If you have a special designation, for example, patent law, trademark law, or admiralty law, these are special designations where, when you're talking about the practices, the areas of law that you practice in, you can use these special designations. If you are a certified specialist, you can discuss the field of law if such certification is granted by an organization approved by an appropriate authority. So in other words, you can say you're a certified specialist in a particular area of law, but only if you actually are approved by the authority or a particular organization of that specialty. Interestingly enough, we move on to this next section because this is very interesting. A lawyer has to communicate his contact information. I can't stress that enough. I don't know why a lawyer wouldn't, but many times they don't. This rule, Rule 7.2, requires that any communication about a lawyer or a law firm's services include the name of and contact information for the lawyer or law firm. Contact information means a website address, a telephone number, an email address, or a physical office location. If you have a website or you have information on the internet, these things are required information in that communication. Now, I'd like to go back for a moment to attorneys referring matters, clients, and cases to each other. Under these rules, it's permitted, and it is permissible. It's permitted when it's fair to both sides and to the client, right? And this is why the rules state that it must be reciprocal between the two lawyers. In other words, one lawyer refers you a case. When you get an opportunity, you refer him a case. It doesn't have to be an exclusive arrangement. It doesn't even have to be a promise between the two lawyers that one will get the right of first refusal, so to speak. But it should be reciprocal because it aids in promoting my apologies, my mic dropped there for a second. It does aid in promoting good relations amongst colleagues. The important thing is that the client needs to be informed that someone else is being brought in or that his case is being referred to a colleague. Payment is not permitted if all you're doing is picking up the phone and saying, "Hey, Joe Lawyer, how you doing? Great seeing you the other night at the at the Mets game or whatever. I have a client in my office. I can't really take the work or the case or whatever it happens to be. I'm going to refer him over to you. By the way, I think you should give me X amount of change or X dollars for that referral." The lawyer's really only picking up the phone and making a phone call. He's not getting involved in the client's case. He's not working on the client's case. He's really not providing anything of value to the client other than finding him a lawyer, which perhaps the client could have done on his own anyway. So the client needs to be informed when that occurs. And at the same time, the lawyer isn't going to be permitted to be paid for making those kinds of connections. Now, if the lawyer works on the case for a while, or if the lawyer takes on a contractual matter and has put in some substantial time into it, perhaps the client is on a contingency fee basis if it's a litigation matter, then that is a different kind of relationship between one lawyer and another when the first lawyer can no longer work on the case for whatever reason, and he has to refer the entire matter over to somebody else, to a colleague. That is not just picking up the phone and calling the colleague up, asking him to take on the case. That is a situation where the lawyers actually put in some hours, days, weeks, whatever, into a legal matter, and not solely referring the client to another lawyer. The rules talk about this. You should consult your state bar rules as well on fee splitting. We're not going to cover this in detail here because it is in another section of the code. But it is something that you should be aware of, because in this section, we talked about how payment is not permitted for solely making the referral. And I wanted to expand on that because referrals are made all the time, and it can be a good source of business for some lawyers, especially young lawyers, as long as they follow the rules. Every jurisdiction is going to deal with these situations differently. So I want to make sure that you consult your local state bar to see what is permissible and what is not permissible. And of course, you should consult the rules before you pick up the phone and make that call to a colleague. Okay, so there are a couple things that I want to address before we conclude the program. Lawyer communication of services in ads also include websites, blogs, Facebook stories and other posts, Instagram stories, posts, Instagram reels, and all kinds of social media. The ABA model rules covers these incidences, but so does your local state bar. So you always need to check the jurisdiction of the state where you practice, whether it's print or online, a directory, or your blog. There's certain areas that you need to be very careful about. First off is actors portraying lawyers. A lot of people today have found that YouTube videos and Instagram reels, Facebook stories, and other social media are really good tools for marketing attorney services. But these reels, stories, and videos are very, very different than the late night TV ads we saw in the years past. Of course, late night TV ads, all day TV ads still exist. However, the ads that are online these days are a little more sophisticated. They're more personal, they're more detailed, but they pack a lot of stuff in just a couple minutes. This is why we need to be really careful. So sometimes in these videos, lawyers use actors. This is totally permissible, but there are specific rules that apply. Again, consult your local jurisdiction to make sure that you are complying with those rules. When creating videos for advertising of your law firm, you have to understand what is ethical in terms of actors. One thing you need to be aware of is if you choose to have an actor portray lawyers instead of using your own firm's lawyers, then you have to have a disclaimer, and it must be prominent, telling the audience that this is just an actor portrayal. And this disclaimer has to appear in this communication. Always remember, folks, that sometimes actor portrayals for your firm can come across a bit staged or not very authentic, and sometimes outright creepy. So make sure that it's done well. Also, in that same vein, is that if you do or have a reenactment of an accident or an incident in your video, then you have to have a disclaimer stating that it is a reenactment and not an actual accident. This is very important. So the disclaimer appears at the bottom of the video or reel, and it should state something along the lines, this is just a reenactment and not an actual incident. And consider that in most cases, it is prohibited to use an actor to portray law enforcement or judges to advertise for your firm. Now, I want to say a couple words about incorrect or incomplete disclaimers. Earlier, we briefly discussed disclaimers on websites. You're also required to have them in videos and reels. But as we talked about, you need to consult your local state jurisdiction for the specific rules. And remember, just because you use one disclaimer in one context does not mean it will be appropriate for another. So know the rules. An interesting question came up with some colleagues a few weeks ago about online reviews. And so I thought it would be helpful to spend a couple of minutes discussing online reviews. You've seen these. I think you know what I'm talking about. They're all over the place. So basically, there's a website for lawyer listings, or it's some kind of lawyer directory online. And then there are stars or points based on the reviews that the lawyer gets. First of all, paying for reviews is against the law, as is giving a fake reviewer a gift or a discount or something along those lines. So that is the first thing that you need to be aware of. No fake reviews. But hey, you don't need fake reviews, right? All you have to do is a couple things to get a decent review, or maybe just a very, very good review from your clients. Most people look at reviews before they make a decision on a purchase. I do. I'm sure you do too. And that includes hiring a lawyer. I know it sounds a bit crazy, but it's very, very common for someone to decide which lawyer to hire after they've looked at some online reviews. Typically, people spend about 6 minutes looking at reviews before they make a decision on a purchase. Maybe they spend a little bit more time if they're hiring a lawyer, but not that much more. Okay, so if you get the chance to have some good reviews, then it will be helpful to your business. How to ethically ask for reviews from your clients. That's easy. Establish trust. Be a good lawyer. Have a good relationship with your client. Do a good job. Developing a trust-driven relationship is not only good for business practice, but it will make your firm better in the long run. After you've established this review and the time with your client has come to an end, either you've concluded the matter or the case is resolved, you can send a review request. And you can send those review requests periodically. And then if you don't get an answer, follow up, ask them again, right? There are a couple other things that you can do to get more online reviews. As mentioned, positive online reviews are incredibly helpful for attracting those who need to hire a lawyer. 84%, 84% of consumers trust online reviews as much as they do a personal recommendation from a friend. So these reviews hold a lot of weight. But going back just a little bit, how do you get these great reviews? Well, you've already concluded the matter for the client. Best thing to do at that point is email them a customer satisfaction survey so that you can get them to start at least thinking about the service you've provided and how they feel about it. That is a good starting point for then later asking for an actual review, right? So they get this email, it has a customer satisfaction survey. There's all kinds of ways that you can generate these surveys online. Very easy, very quick, very cheap. Don't be concerned or too concerned about bad reviews or worried that bad reviews might come in. The reason is bad reviews are a huge opportunity for you, not necessarily a problem. The way to deal with a bad review is to address it immediately. How do you do that? You contact the client and you ask them details regarding the bad review. That way the client feels heard. You don't want to jump too quickly into trying to fix the problem, or they're going to think that you didn't really take time to understand how they felt. So the first thing is you want to listen, let the client know that you are paying attention to what they're telling you, ask questions, and then validate the client's feelings. They want to know that you understand. And then at that point, focus on solving the problem, whatever the problem was. Let the client know that you understand the problem and you understand what the client's needs were or are, and that you are working to resolve that problem. And then once you've resolved that problem, ask the client to edit their rating. Most clients do. If most clients walk away happy or their issue is resolved, they will edit their review. This is a very good way to get a positive client feedback online. People look at these things and they become very, very important to your practice. Another way that's connected to online reviews is, and just having an online presence, is you can hire companies to optimize your SEO so that when somebody types in lawyer that does this and that in a particular region, your name comes up. And there are ways that you can optimize how you can have a greater presence in that way as well. But the easiest way to get more presence online without having it cost too much is these online reviews. Do the customer survey, find out where your clients are, and then ask them to post a little something about you if they feel like it. Okay, so we're coming to the fun part of the program right here at the end. On the whiteboard, you will see some examples of violations of ethics rules on communications concerning a lawyer's services. I want to go over a few examples. Some are extreme examples. Some are very common. I don't want to stress that this is fun or funny, but you can't help but chuckle at some of these ads that are real that have caused our colleagues to be admonished. Let's look at the board now, or at the screen now. A TV commercial where there's a scene of a group of guys around a table, and they're playing poker, and the camera kind of spans the table, and you see these guys playing cards, and it focuses in on one guy, and the guy's cheating, and he's winking at the camera, and he's taking cards out of his sleeve and all kinds of stuff like this. And then at the end of the commercial, there's some reference to that the poker player represents insurance companies. It's a scene of a poker player cheating. That's what this commercial is about. The lawyer in that case was admonished because it implied that the insurance company, or all insurance companies, will act dishonestly when dealing with your claims. The commercial was pulled off the air, and the lawyer was admonished. There was also a newspaper ad some time ago. I don't know if you saw it. It was out for a while. It was in newspapers and magazines. And there was a tagline in this photo of a bunch of guys sitting around a desk signing contracts. And the tagline said, "We guarantee that you will pay no closing costs." It was regarding closing costs in a real estate deal. The lawyer in that case was admonished for that ad because, why? There actually were closing costs. He just called them and characterized them as expenses to the client, but they actually were closing costs. And the client complained. He said, "Hey, you guarantee that I wouldn't be paying any closing costs, and this thing that you're calling is an expense is actually a closing cost." The court agreed, and that lawyer got in trouble for that newspaper ad. There was also another print ad, and I'm sure you've seen this all over the place, where there's a statement that says, usually it's at the bottom, a nice picture of a law firm or a bunch of lawyers standing around. And then it says something like, "For over 40 years, we've been putting experience, knowledge, and skills to work for people like you." Well, in that case, the firm hadn't actually been in existence for 40 years. The 40 years was actually all of the lawyers' combined experience that added up to 40 years. So I think in that case, there were 4 lawyers that each had about 10 experience, and that's how they got the 40. That was considered a misleading ad. And the lawyers, all of them, were admonished for that ad. Pardon my typo there in the word lawyers. Moving right along, I'm sure some of us have seen these newspaper ads um, where they'll have one toll-free number and then it says, call our toll-free number, 1-800 whatever, to reach our offices in Los Angeles, Dallas, New York, and Chicago. Except for one thing, the firm did not have offices in any of those cities. So the lawyer got this 800 number to make it look like they got offices all over the place. That wasn't the case. And this was considered a misleading ad. And the lawyer did get admonished for this as well. In these cases, sometimes lawyers are getting admonished, and sometimes they are getting in much more trouble than just admonishment. It depends on the jurisdiction, it depends on the offense, it depends on how many offenses have the lawyer has undertaken over a period of time. But in any case, these are ads that I pulled up because they are interesting and not that unusual. But they do bring across the characteristics of these advertisements that seem on the surface like they would be okay, but they actually aren't, and they are prohibited. There was a direct mail ad that came out, this was quite some time ago, and in the ad, it said, it was an ad for DUIs or moving violations or something like this. It's in the ad, it said, absent a legitimate excuse, we require the officer to be present at the trial setting and to possess the proper documentation for your case. Well, a lawyer cannot require a police officer to be present at trial, right? Only the judge can do that. So any prospective client that thinks that a lawyer can actually force a police officer to show up at trial is being misled by a statement like this. This is prohibited. This was actually an ad that ran by a couple different firms in a couple different states, and they all got in trouble for this kind of stuff. There was also another direct mail ad back in the day when there were a lot of direct mail ads done by lawyers. This ad came out and actually said these exact words. So the ad had, again, a photo of this firm or a courtroom or whatever. And then at the bottom, it said, we know the judges, the police, and the DA, and have good working relations with each of them. Wow, right? This is implying that there's a special relationship with these people, and that was inappropriate, and this suggested that the officials could be used to help a prospective client get a good result. It's not actually coming out and saying that, but that's the gist of this, right? We know all the important people in town hire us because not only do we know them, but we have great working relationships with them. That's extremely misleading. A client is going to think, oh, wow, this guy can get me a good result because he knows all the right folks. This was considered misleading and a violation of the ethics rules as well. There was a postcard ad not too long ago. It was kind of cute, and on the surface, it doesn't seem like it was hurting anyone, but it was a violation of the ethics rules. So in this ad, there's a photo of two lawyers standing before the judge, right? And lawyer one says, Your Honor, We have photos, taped conversations, and a signed contract. And then the judge says, give it up, counselor. You can't win against ABC law firm. Well, it's a cute ad, right? But it's implying that the firm, ABC law firm, could not lose a case even in the face of overwhelming evidence to the contrary. That's misleading. It's going to lead a prospective client to believe otherwise. And this was considered a violation of the rules, as is the postcard ad that we are looking or just going to discuss right now. So there's a postcard ad. It's out, again, a really nice glossy picture. And on the bottom, the tagline was, on all matters of law, we've delivered. Well, that kind of implies that the law firm had handled and won on every single conceivable matter possible in the law. And that is just not the case. The law firm did not handle every single conceivable matter possible in the law. This ad was considered misleading. These are just a few quick examples of what not to do. I drew on these examples because on the surface, all 8 of these seem like, first of all, they seem kind of okay. And second of all, you would think that anybody looking at these wouldn't believe that that the law firm meant all possible matters, or that you can't win against ABC law firm, right? It's anyone would think that this is supposed to be tongue-in-cheek, but that's not the case, because the ethics rules are there to protect the public from misleading statements, and these statements are misleading. So you have to be very, very careful about how you phrase things and how they are portrayed and delivered, both in print and online. And let's not forget that anything online stays online for a really, really, really long time. There's no getting rid of it. So make sure that whether it's online or in print, that it's not violative of any of the state bar rules or the ethics rules in your jurisdiction. To an end of this program, and I have a few concluding remarks. Today we covered the ABA Model Rules 7.1 and 7.2. These are regarding communications concerning a lawyer's services. In fact, that's the title of the section in the code. Communications concerning a lawyer's services. We discussed this in the context of advertising, marketing, promotion, and in ways we try to get new clients and new business, because all these communications about our services, who we are and what we do, what we can do, what languages we speak, how great we are at certain areas of the law, of what specialties we may have. These are the ways that we use to get clients. As we discussed, these communications involve both in-person, one-on-one solicitation or communication or discussions. They might not always be solicitation on one-on-one, but they border on that, as well as advertising to the general public at large. The purpose of these ethic rules are to maintain the integrity of the profession and to instill confidence and trust in lawyers. And unfortunately, sometimes we find ourselves in a situation where members of the public have lost confidence and trust in members of our profession. And so these rules are designed to protect them, but also to help us and to guide us into being better lawyers and better business people, better citizens. I hope that you have found this discussion useful and helpful. As I've stated several times before, please consult your local state bar, the jurisdiction where you're working in. If you're working in more than one jurisdiction, if you are certified in more than one jurisdiction, you need to consult the state bars of the jurisdiction where your client is located, where your work is involved. If it's a litigation matter and you filed in a particular jurisdiction, then you have to abide by the rules of that state. If you are conducting something outside of litigation, transactional work, and it's multi-state, you have to abide by the rules and consult the rules of those multi-jurisdictions as well. I thank you for joining me today. I hope that you have enjoyed this program. This brings our seminar to a conclusion, and I wish you the best of luck in all your endeavors. Thank you so much.